The series that we have been doing with Lydia, might be the fourth, I can't remember. Um, and yes, on education healthcare plans. Lydia is a solicitor at Boys Turner, and she is the Queen of EHCPs and the author of now second book, not one but two books on EHCPs. The second book is not quite yet to be published. It's coming out soon, and we'll be sending details to everybody who's joined the webinars in case they wish to see that. So I will now hand over to Lydia.
Thank you. Thanks, Sally. Yes, so I'm going to talk about, in a sort of whistle-stop tour, but the EHCP appeals process. Again, I appreciate this is something where some of you may be in appeals or looking to start an appeal, and there are lots of points to cover on it. So I will do my best to go through them and to answer your questions on the topic as well as best as I can within the time as well. That's a little bit about me. I have put a link at the bottom there to my second book, which is with Law Brief Publishing, and it's covering EHC needs assessments through to EHCPs. It's covering that process. So if any of you thought, might find that useful, there is a link there that you can go and have a look at it.
And we'll also forward the link to people afterwards.
Thank you. Okay, so this is what I'm aiming to cover today. So a very quick overview of what the SEND or the SEND tribunal is, what it does. EHCP Appeals in a bit more detail, and there are different types of these appeals, as you will see, but we'll be focusing on one particular type for this webinar. Appeal timetables, which are quite sort of hot topic at the moment in sort of the SEND sphere, I suppose. Hearings, so appeal hearings, and options. The last point, that's kind of addressing points that will have been covered in the previous sections of the slides. So yeah, I will do my best to get through all of it for you. So SEND, so Special Educational Needs and Disability Tribunal, they are an independent tribunal, so separate from local authorities. They're their own standalone system. The SEND tribunal is part of the first tier tribunals in England. You also have upper tier tribunals as well. But for the purpose of this one, it's focusing on the first tier tribunal. That falls under the health, education, social care kind of remit. So that's where the SEND tribunal comes into it. And first tier tribunal appeals are certainly in the work that I do, that is the most common. And that is probably what, if you've been involved in EHCP appeals or you're planning one, that's who you will be appealing, to, is the first tier tribunal. Tribunals are made, well, we'll get onto this when we talk about hearings, but tribunals have judges, so someone who's legally qualified, who will make decisions across an appeal, including at hearings. There are also, you have other members of a tribunal panel, so are specialist members, so they may not be legally qualified. You also get clerks, you get there's lots of different people involved in the tribunal system, registrars as well, lots of different people at different stages. The first tier tribunal. They hear appeals in relation to different areas of the EHCP process. So some examples are refusal to carry out an EHC needs assessment. They address refusal to issue EHCP appeals. So that's the second stage. If a local authority ceases to maintain an EHCP, or they've decided that they're going to cease to maintain an EHCP, they hear those. Refusals to carry out reassessments, and also appeals on the EHCP content as well, which is what the key area of this will be looking at. So I think EHCP appeals are a good one to talk about because they are ones which probably a lot of people will have been through, may have well have also been through previous appeals, so refusal to assess, refusal to issue. But I think EHCP appeals are the ones where it's worth focusing on for this, and just because it's quite a it gives quite a few examples in terms of the appeals process, specific things to consider. So appeals about an EHCP content, so that is looking at the needs detailed in that EHCP, so the special educational needs, the provision to meet those needs. It can also look at placement. So those are your educational sections, so B, F, and I. You can also include health and or social care. So section C and G and D and H. The key thing with bringing in health and or social care is you have to have an appeal that's addressing an educational part as well. So it would need to be a BNF or a BF&I plus health and or social care. And for any part of that appeal, you would be saying what changes you want made to your EHCP, what you don't agree with. That's what it's the similar process for health, education, social care. There is a distinction between the educational sections. Decisions made by the tribunal on those sections are legally binding on the local authority. Health and social care, the tribunal makes non-binding recommendations. So these are not legally binding on a local authority to carry out, but they are essentially taken as they really should be, because this has come from a specialist SEND tribunal. They've made this decision based on the evidence. So there is a distinction. And with this kind of appeal, and with any of the other appeals, the aim is that you try and resolve what you're looking for in the EHCP with the local authority. So the aim is that you work together through the appeals process, try and reach agreement. And if you do, you can then ask that the appeal is concluded by consent, to say we don't need the tribunal, we've actually sorted this out, we can close it, close the appeal off. And this does happen, which is always nice when it does. And not all appeals though, because each case is different. And as we'll go on to look, it's also dependent on the evidence, the issues, that sort of thing. So there's different things to be aware of. So one of the kind of key, I suppose, factors that we're experiencing at the moment for EHCP appeals to the tribunal are the timetables that are being issued. And this is from the point of once an appeal has been lodged with the tribunal, say on, an EHCP sections B, F, and I, this is then, once it's been registered, there is a timetable that will be set by the tribunal to say, here are certain deadlines that both parents and local authority must meet. The timings I've given on here are approximate, but kind of based on what we're sort of seeing. But then, again, it's not to say they're always around these times, but generally, from the point of registration, the first deadline is at week 6. and that's for the local authority to respond to the appeal. And that is saying, do they object to what the appeal is raising? Quite often at that point, there's not much that they can come back on, because usually an appeal has been lodged. It may not have all the information you need. Maybe you're waiting on updated evidence. So it might be not have as full a response at that point because there might not be the information. But that's their response deadline. They also have to provide set information about the current placement if there is one. It's about addressing the legal requirements of what an EHCP, how detailed it should be, what it should include. So that's the first point. You then have quite, again, generally not set in stone, but there's generally not a huge amount of time then until your further evidence deadline. And that applies to both parties, so local authority and parents. And that is to say, what additional information that you've not already submitted are you relying on? So what are you relying on to support the changes to the EHCP that you're asking for? So common ones will be expert reports. So educational psychologists, speech and language, occupational therapy, physiotherapy, potentially quite a lot. That is the deadline for both parental and local authority evidence. And again, because the timetables are get a bit potentially difficult practically to kind of manage, and we'll come on to why that is, it may well be that 14 weeks is too soon to meet for evidence. So you need to ask for more time, which is through a formal process with the tribunal, submitting a form, a request for change form, seeking local authority views first, confirming why you need the extra time, what's it for, why will it help the appeal, why is it needed? And then that goes to the tribunal to say we need this extra time. And generally those don't cause issues if the hearing date is staying the same. So that's something that is often utilised because the timings otherwise are quite tight to try and meet that 14 weeks. This is also factoring in, when experts may be available, time to visit schools. There may be unknowns, they may not know, they may not be a confirmed school at that point for them to visit. So there's potentially different things and reasons why more time is needed for further evidence. The next deadline is then very soon, generally after further evidence. And this is the further evidence deadline that's set rather than if there's an extension. You're then looking at submitting your case review form. These used to be attendance forms, which would set out who would be attending the hearing as witnesses. Now it's a form which provides more of an overview. So it sets out the outstanding issues, witnesses for the hearing. So those are often experts who've assessed, someone from the school, that sort of thing. Scope of any agreement, details about placement, if there are two placements, or that sort of thing. So any other issues that you want to flag with the tribunal as well. It's also a chance, if you've not already raised it, to say, well, we might actually want a paper hearing. So hearings, which we'll come on to in more detail, but hearings are generally held remotely and in person, so kind of like this. But there is the option to ask that the tribunal panel of a judge and specialist members just review the papers and they make a decision, and there isn't any video hearing. It's just based on the papers. So there are different things that you need to kind of flag in this case review form. Practically though, if you're asking for late evidence, which is quite common, it then also follows that an updated case review form is needed, because the issues might have moved on, and actually there may have been further developments and the witnesses may have changed, or you may not know your witnesses by week 16. So that's something else which does happen, to again try and keep it up to date to say this is the current situation at the moment. So it's all quite front loaded, considering you've lodged the appeal. It's then by week 16, you then in theory got to a point where you're saying this, our evidence is in, these are the issues, here are our witnesses if it gets to a hearing. The case review form date is also the point where you are providing an update about the working document of the EHCP, which is the EHCP in a Word document, and it is worked on by both you and the local authority to show what proposed changes you're asking for. And again, that's going to come from your evidence, and that evidence may not be available by week 16. So quite often those updates might take time as well, and they may not happen until you've got the reports in, other updates, schools, So again, that's a working, that often takes a bit of time. So yeah, front loaded, but there is scope to push things back if you need to.
Great. Lydia, are these dates set out clearly at the start? And if so, by who? And if not, do you need to keep track of the timetable yourself as a professional? And who keeps an eye on all of the deadline dates?
So the tribunal will set out these. You'll get a registration of appeal letter saying your appeal's been registered. There's quite a lot in it. And then there is a very helpful, I find, key, like one page where it sets out a table saying LA response due by X date, evidence due by this date. And then it gives a breakdown of what's required at those stages. So the tribunal sets it. They are the ones who technically should be keeping an eye if dates are missed. So say if the local authority does not respond by week 6. However, the tribunal is very just sort of kind of at this capacity, which seems to be getting worse. So I would say to also keep an eye on it. And if week 6 comes and goes and the LA has not responded, then yes, that is something to be flagging, to say, well, you've missed your response. So you need to be proactive with it. Don't rely that the tribunal will, because they have, I don't know how many appeals, they have a very, very large number that gets bigger every year. And they always issue stats about how many it is. And it's always, this huge amount. So it's worth you keeping an eye on them, on the deadlines as well, just in case something does get missed.
Just before you go on to the next page, another one is due to the tight timing once an appeal is lodged. Do you advise parents to apply for the medication cert to then get an additional month to do their appeal with expert evidence, if obtained by then, or please bear with me, or lodge the appeal as soon as, within the 2 months of the final amended EHCP, if they're appealing RE, BF, and I.
So that's the mediation certificate, I think is what's, yeah. You have to have a mediation certificate before you lodge an appeal. Each case is different. Some cases mediation may be worth requesting. Otherwise, you just say you've considered it, and that's enough. Given how long tribunal timetables are, which we'll come on to, the total, I think it's probably unlikely that having an extra month is going to give you the time you need to get experts in to lodge an appeal fully with all your evidence. You may do, some cases you may be going in with the reports already, and that's fine. Obviously each case is different. It's just being aware of how long these can take, these timetables. And so generally I would say no, just lodge it, because then you're in the system at least, and you can still negotiate with the local authority to try and resolve matters. And yeah, unless you think it's workable to actually get your evidence in and ready before you lodge an appeal, if that's doable, then sure, you can absolutely do that. But again, it's just being aware of the overall timings that the appeal could take anyway once you get into it. So it depends.
Getting it lodged is the important thing, isn't it? It's getting that
Lodged and then registered. Is, because once you've got it lodged, tribunal also has to register them. And
Sure.
again, we've experienced issues where that has been delayed, which has then caused delays in the whole process. So yeah.
Thanks, Lydia.
Yes. So this is the full timetable, again, based on kind of what we're experiencing. I'm not saying this is an absolute, but from our experience, we are finding that appeals being lodged, being registered, you are then getting up to 14 months from that date is the date of your final hearing. So this is why, and this is why being aware of these timings is so important going into it, because you are looking at worst case a year, if not more. And that date has got a bit larger. There was a time when I think appeal timetables used to be 12 weeks from beginning to end, and now it's this huge it's this huge gap. But the issue, as you will see, is because there's such, generally on the timetables that, again, from our experience, we're seeing on average there's a huge gap of several months, sort of 6+ months, from once your evidence has gone in your case review form, then your hearing is so much later, which can cause a lot of difficulties. So this is why it's often just a case of get an appeal in. And something is worth clarifying is that these kinds of hearings and these timetables I'm talking about are not including transition, EHCP transition appeals. So I'm not talking about secondary or post-16 or post-19 transition appeals, because they generally have a shorter timetable, because the aim is that they will be sorted before the September, when the child would then start at their next stage. These are just ones where it's any other kind of EHCP appeal where you're not dealing with the transition between stages of education. And yes, that's this is what we're experiencing. So as I've said, the hearings are generally remote, usually a day, sometimes they're half a day, depending on what the appeal is addressing. And it's where you bring the witnesses, you have the judge, specialist panel members, and by this point, this is reviewing what's been submitted as evidence, the working document, what did the witnesses say. Witnesses are required to have submitted a report and or a witness statement as well. There's generally a maximum of 3 witnesses. You can apply to have more, but again, you have to give reasons. Remote hearings can take longer than a day. They can be postponed, adjourned, all sorts of things can happen. So that's one option. You do also have the option for a paper hearing, which is, again, no panel, no witnesses. It's just based on the papers that have been submitted, so the evidence, etc. And the panel then makes a decision on anything that's not been agreed, and then that's their decision. Not on an EHCP appeal, but on a refusal to issue appeal, I had one where there was a remote hearing booked, and then a paper hearing got set instead, and that brought it forward by, I think, about 4 months. So it actually brought things forward, because the tribunal for a paper hearing, my understanding is they don't need to all be available at the same time, in the same to attend this remote hearing. So I think it does allow a bit more flexibility for them to potentially move things. But again, it very much depends on the tribunal at the time. Paper hearings are not always appropriate either. Some cases you do need your witnesses, you do need to address the issues. So sometimes it has to be a remote hearing. Other times a paper hearing is appropriate, and if it gives you the chance of potentially getting an outcome sooner. But there are risks, there are pros and cons with both. Remote hearings, you are obviously factoring in costs for witnesses to attend, any legal representation. You are also, but there's a potential that it can get adjourned to a second day, or there might be sometimes closing submissions get written afterwards. There might be extra work. They're also very tiring days, hearings. They're very full on. But it obviously gives a chance for witnesses to be questioned and to put things forward to the tribunal. Paper hearing, you obviously don't have the cost and the time to attend, so you have no witnesses attending. You are instead solely relying on the strength of your paper evidence that's gone in and the evidence of what the local authority has submitted. There is also a risk with either, but more so with a paper hearing, where the local authority might say, well, we've got late evidence, and that comes in close to the hearing. And then if you're in a remote in-person hearing, you can at least then address that and follow up and say, oh, is there any objection? Why is this so late? If it's on the paper and you're not there, you're then kind of, you can put your views forward in writing, but then it's ultimately with the tribunal to make that decision. There's pros and cons with both. Again, each case is different, and yeah, this is essentially kind of what it looks like at the moment anyway.
Lydia, who decides originally decides whether it's a remote hearing or a paper hearing?
So when you lodge an appeal, you can request from the outset. You can say, I want a paper hearing, I don't want a paper hearing, I don't know about either yet. Both, if you wanted a paper hearing, you and the LA would have to agree, and then the tribunal would say, yeah, we think this is suitable, we'll set it. Generally they are generally when you lodge an appeal, it's too soon to tell because you don't know what the evidence is going to be. I don't think you can say for certain, well, we want a paper hearing, because you may not know all the issues. But that can also change. So that might change when you get to your case review form, and you might say, oh, actually, we think paper hearing is going to work. Otherwise, it is, yes, for these kinds of appeals, it is a remote hearing as standard, and that's the tribunal who sets those. But even they will sometimes reach out and ask parties, parents, local authorities, oh, actually, do you think this is suitable for paper hearings? And sometimes even they'll approach and say, we think this might be fine for paper hearing. What do you think? So again, it depends.
Question. When you're talking about the appeals, is that where it actually goes to tribunal, or is there a stage in between? You mentioned, Lydia, mediation earlier. Would that happen locally first, and then would it go to tribunal if not resolved at this stage? And who would generally be used as a witness?
Witnesses depend on what your evidence is and who your experts are, and the school, if school placement is in dispute. Mediation, the mediations I've been to have been remote as well. So, and again, the mediation is separate from the tribunal, they're separate from local authorities. Mediation would have to happen, if you're going to do it, happen before an appeal. You don't have to go to mediation. You can just consider it. Again, each case is different, and some may warrant mediation before an appeal. And yes, if you resolve matters in mediation, then yeah, you don't have to appeal. But generally for EHCP appeals, when you're looking at content and placement, an appeal is needed, from experience. But that's not to say that throughout an appeal you can't keep the negotiations up with the local authority to try and resolve. Sometimes it's just you need to safeguard that right of appeal, so you're in the system, because if you've got an EHCP that names a school that you don't agree is suitable, or it doesn't name a school, which it can do, it can just name a type, then it's about, well, just getting into the appeals system. And at least then you've got that safeguard.
Yep.
So I think some of these I've covered already, but it's really focusing on the fact that current timetables at the moment are what they are, and they're not really workable for a lot of the time. So requests for late evidence are common, and these are usually without issue, because if the hearing date is so far off anyway, it's not going to affect it. It's also, I suppose, actually, when you lodge an appeal, flagging if there are any issues at the outset. So is it a case where the child or young person's out of placement, so we want the tribunal to set a timetable that would, in theory, expedite things? Is it a case where you've had an offer from a school, but that offer will expire, so you want it to be factored in? These are things that you may still have to flag up once an appeal is registered, because it may well be that the timetable is still set and the hearing date is too far away. So you're then, again, which is something which is becoming quite common, like from my experience, asking for an earlier hearing date. So it may even be that you need to ask for late evidence because 16 weeks is too quick, but also to bring the hearing date forward. That may be for various reasons. That could be because the placement offer might expire. It could be that, there's no, that the expert reports rather are in, and you don't want to risk them becoming potentially out of date. That's another thing with potentially how long the timetables are. You might have evidence going in, and then 6, 7, 8 months later, things might have changed. There might have been updates in the child or young person's profile of need. There might be a new diagnosis, or something might have happened. So you're then potentially otherwise looking at, well, do we need to get updated expert reports, which sometimes has to happen anyway, to address these updates, or there may be updates in terms of placement. So unfortunately, these things are, you kind of just have to go with what the situation is, try to plan ahead, but it's also factoring in potential further costs for experts to do their assessments, to visit schools. Something that I've not covered on here, but I can always send actually to Sally afterwards to share. The tribunal has issued, which is in place, practice direction in terms of how expert reports should be prepared for appeals, because there is now a page limit of 15 pages. There are other requirements, but the main thing, I think, is the fact that it's 15 pages now per report. There are also limits on the number of pages for the working document. There are limits on to try and condense the appeal bundle, because some bundles were hundreds of pages long, which for a lot of it, by the time you get to a hearing, you probably don't need a lot of that. So the practice direction, I think, is aimed to focus the issues. So it's very much addressing what are the key things. So I can forward that, Sally, because it's worth people being aware, actually, that this is something to have that information. And then, yes, again, paper hearing we've already talked about. Not all cases will be good for a paper hearing, but some may be. And for all of these requests where you're asking for a change in a deadline, something, it's the same form, tribunal form, request for change form. It's fairly self-explanatory to kind of complete, but the key thing is that you have to approach the local authority for their views. My understanding is you have to give them 5 working days to respond. Sometimes there's scope to push that if it's very urgent or there's an upcoming deadline, but it's to show that you've put this forward to them, given them a chance to confirm if they agree, if they disagree, and then it goes to the tribunal, who then will decide and issue an order. So any changes to the timetables will come out in orders, and you then have, hopefully it will address what you've asked, so whether it's a late evidence extension, whether it's a paper hearing, something else. And generally on those orders, you then have a chance to object if there's something you go, actually, no, that isn't what I asked, or this date won't work. And again, that happens as well. It's then the same process of going back, confirming what you're seeking, why are you asking for it, any new timings, what does the LA say? So there are ways to address it, but again, it's just stressing that the tribunal's capacity seems to be just getting more and more, just every year. There's so many appeals. So being proactive on deadlines, making sure you ahead and almost working backwards from, right, if this is hearing, if this is evidence, how much more time will I need for evidence? When do I need to start, planning to ask for the evidence? And it's, can I do that now? To kind of just give yourself as much of a chance as you can. But just being aware that sometimes the tribunal will issue things and you have to kind of make the best of what they've issued. Sometimes there are limitations on what they can do. So for hearing dates, they may say, well, we haven't got capacity to list it within the time frame you're asking. They might offer the next best thing. It's very tricky. I suppose what I would say is that if you're in an appeal or planning to lodge an appeal and you're not sure, then to seek advice, even if it's just, I'm not quite sure how to deal with this particular process or how to kind of plan, because there are potentially lots of timings that can change. Each case is different. I say that all the time, but it is true. In each case, it depends on the evidence, your experts, school. It'll also depend on what's agreed throughout an appeal and how much is resolved, because then you might start off saying, well, it can't be a paper hearing, or we're challenging school, but actually as things move on, you might reach agreement. It might get a school that you agree with, and then other issues may narrow it down. You may go, well, we can do a paper hearing because we've narrowed it down to these issues. So
Right.
Other times it may not be. It may be, no, from the get-go, they're saying one thing, we're saying this thing, we've got our experts, they've got theirs. And sometimes it's that, and it goes like, well, that's it. It's got to be discussed at a hearing, and then the aim is that the tribunal panel is then there to sort of pull out these issues and to say, right, where's your evidence? What's your evidence? That sort of thing. Yeah. So they are on certain timetables, which isn't nice, but like I said, it's worth to seek advice if you're not sure about a particular stage, the whole process in general, whatever it may be, planning for a hearing, that sort of thing.
Lydia, there's some input from Misha, thank you. For section 10 of the form 35, you need to lodge for an appeal. How much detail do you need to go into, i.e. what your appeal issue is, i.e. why you disagree, what evidence you have, what action you want to take, especially if you don't have all of the expert reports at the time of lodging your appeal prior to the expiry of your deadline to do so.
That's a good question. The appeal form, so the section 10 part is that is to say what sections of the EHCP are you appealing. So making it clear, is it sections B and F, BF and I? There's a separate page, I think, for health and social care. Yes, sometimes it is limited and you don't have all your evidence. That's quite common. It's really about, I suppose, picking out what's in the EHCP at the moment that's wrong. So is section B, is it missing any diagnosis? Is it missing needs that it should be in there? Or is there provision in section B which actually should be in section F? Even if it's just, sometimes it's that level where you go, well, based on the EHCP as written, these are the things. Or it's also to flag that updated assessments are being gathered and reports will be shared, to help inform. It's just to give that initial point to say what sections and as much as you can based on what the EHCP says and any available evidence that you've got, what are you appealing? Again, it can be as simple as section F is not specific and quantified. Here is an example, you know,
Okay.
or the one-to-one isn't clear, or some, even if it's that. But again, saying we're getting up-to-date reports, they will be submitted when available. Placement, again, if you've got a confirmed placement, then that makes it simpler. Even if you haven't, it's again giving as much detail to say, well, we don't agree with the placement that's been named, or no placement's been named. We are looking for this type, or this, you know, we're inquiring with this particular school. Sometimes that's all you can do, because a lot of this won't come out until you've got your experts involved, and then schools are often consulted through appeals anyway, and potentially new schools. So that may change. You may start off saying we're looking for this placement, and actually it becomes something different because evidence comes in, local authority may suggest something. So yeah, do what you can on those forms. But again, if you're not sure ahead, then it's worth just seeking advice to say, is this sufficient? Any, you know, generally the form I think is fairly sort of straightforward to complete, but again, it's about each case will be different in terms of what you're specifically asking for. But yeah, make the sections clear, and then as much detail as you can at that point.
And this may have answered the next question, but what happens if the current EHCP is already too long due to a very complex child? It's a very good point, isn't it?
So it's fine if you're lodging it. The tribunal won't, I believe, doesn't cap the number of pages, because the EHCP is the EHCP that's been issued. So the page limits come into it more when you're looking at the working document. So it's 25 pages, is my understanding. So if you've got an EHCP which is more pages than that, which, you know, does happen, the EHCP itself will be fine, because that's gone in to lodge the appeal. The tribunal that's the document that has to go in. But it's then your working document is when it gets condensed, and the tribunal has I think it's in the practice directions, but I think that they've said that it's only the sections that you are appealing. So previously it would be the EHCP copied, but now, so if I've got a B, F, and I would, all the other sections I will take out, and it will just be sections B, F, and I. You won't have health, social care, section A, you know, none of that will be in there, because the tribunal said we just want the sections that are being appealed. We want to keep it within the page limit, because it which makes sense. If you're not appealing a section, why, it doesn't really add anything to have it there. It's just adding pages. So yeah, the EHCP itself is fine going in, and all the appendices as well, I should say, they will fall under that as well, because they're required. But again, going forward, the plan is that you have up-to-date expert assessments to help like focus on the key issues. So yeah, it's yeah, it's just trying to streamline it, which I do get, but yeah, you have to give it a bit of thought.
Okay, just one more from Michelle, thank you. And please, guys, all your questions will be answered. They will be there and sent. The answers, if and how Lydia can answer them, they will be sent afterwards. But this one is, does that mean your section A parent section is also removed, as that could be helpful background for the tribunal and your case?
So from the working document, yes, I wouldn't expect to see it in there, because it's not a section that you can appeal. But because the EHCP will be in there when you lodge the appeal, your section A will still be in there. So the tribunal will still be in the bundle for the tribunal, but it won't be in the working document EHCP. So it will be in there. Yeah, and I suppose also another thing about if it's a remote hearing, that's also an opportunity for parents to give an update and to give because yeah, a lot could change within a year from when they lodge the appeal. So that also gives the opportunity. And there's things like parental statements you can do as evidence to say, here's an update. So there are other ways you can do that as well.
Can I give you one more?
Oh, why not? Why not?
I've lost my around. Thank you, Katarzyna. I'm an SLT. Can my health non-EHCP SLT report be submitted as evidence without me being a witness at the tribunal if I do not offer tribunal services? Oh.
Yes. Yes, you can have a report and you don't have to call them as a witness. Because you may have lots of experts and you can have a maximum of three, so it may not be possible to call all of them. Yes, you can do that. Yeah.
Good. Okay.
A simple answer.
Yeah, yeah.
Yes. Super. That's great.
More.
So are there any other questions in there at the moment, Janet, that
Nope.
we're going to... That's great. Good. So what we will do is after this session that we will be posting this video up so that if you want to watch it again or share it, and we'll also forward the practice direction so that that you've got that as well. And I think that was probably about it, but and also Lydia's contact details as well, so that you'll have her contact details, which are on the screen now. But if you don't have a chance to write them down, we will send you those as well. So thank you very much, Lydia. Another very interesting webinar full of information. Just as one question, actually, I was just thinking is, do you know what the percentage of appeals are successful?
Do you know what? I get asked that. I don't really have an answer. I know for refusal to assess appeals, the first stage, the percentage was like in the 90% from memory. It was very high. Might have been 95 or something. But for EHCP content appeals, I'd like to say that it's high. I couldn't give you an exact figure because again, each case is different. I wouldn't be able to kind of pick it out. But I think the thing I would stress is that each case is always dependent on its evidence and what happens and updates. But also the fact that quite a lot resolve through negotiation is, that I would say, well, that's a success, that's a win. But again, whether that's an option depends. Sometimes it's just not, and sometimes you do have to go through to a tribunal, and then it is reliant on the tribunal making that decision. Yeah, I'd like to think it's high, but I can't kind of base that on any.
Yeah, sure.
Yeah.
Just lastly, Lydia, and it's a question that you can reply to because the questions were put to Lydia afterwards, which is about any specific advice about an appeal against a refusal to issue an EHCP.
Any specific advice? Yes. In theory, it's about showing that the level of special educational provision that the child or young person needs is higher than what a standard maintained mainstream setting could reasonably provide. So essentially, could a maintained mainstream school or college, could they provide that support through their resources? And if the level of provision exceeds that, then you would argue and say, well, it can't, they need an EHCP to secure additional funding and resources. That's what a refusal to issue is addressing. It's that sole point. But again, each case will depend on your evidence. So it's probably worth, if the email address is included, I can always respond to that directly anyway.
Great. And I think there's another one here, sort of a couple of follow-up questions, Lydia, which I think could be answered directly after, if that's okay. Misha?
Super. So we do have one more in this series, as you can see on the screen there, which is Wednesday, the 18th of February. about cease to maintain EHCPs and what should be considered, not considered. And we will be sending out the links. I think the link is already on Eventbrite, but we'll be sending the link to this next one out when we send out to everybody who's signed up for this webinar with those other things that that we have mentioned, so that you'll have all of the information. Super. So I don't think, yeah, that was everything. So yeah, thank you again, Lydia. That was really great, and thank you everyone for joining. It was it's always nice to see everybody joining these, and I hope that they are useful for you to give you a bit more information, trying to navigate this rather complex system. So yeah, thank you very much, Lydia, and we will be forwarding your any questions over to Lydia, and we have your email addresses. As long as you registered to get your seat here, then we'll have your email address, and we can then forward those to Lydia, and she'll reply to you individually. So super. So thank you very much again, Lydia, and goodbye for now.
Thanks.
Okay.
See you, everybody.
Cheerio.
Bye.
Bye now.